What's up, everybody? Welcome into another video here about Sarah Boone complaining about a lawyer. Is she right? Does she have a legitimate gripe at this point? Is this something we expected? We're going to talk a little bit about how the appellate process usually goes between a lawyer and a client, but we're also going to take a look at something that could be a much, much bigger issue that I hope is something I just missed or am completely wrong about, because if not, things are going to get ugly here for Sarah Boone and her new appellate counsel. Let's get to it. So we're going to just jump right into Sarah Boone's most recent filing, pro se. She is still out there fighting for herself and representing herself, at least in this motion. And she gets a response, which is really something. She keeps fighting for herself, advocating for herself, being the voice that she needs. This is the state of Florida v. Sarah Boone in the circuit court. Notice of inquiry. Basically, I've got a question. Comes now, Sarah Boone, pro se, and files this notice of inquiry with the clerk of the circuit court in the above referenced case number, inquiring as to the status of appointment of appellate counsel. The last entry on the docket in this case shows that Joshua Adams Esquire was appointed to represent the defendant on December 18th, 2024. However, she has not received any correspondence from him. So he has not spoken to her. That's concerning, right? They should probably talk at some point. It's been a month. But we'll talk about what's normal in the appellate process. However, she has not received any correspondence from him, and her application of indigence to be appointed an appellate attorney was not filed with this court until December 23rd, 2024. So we reviewed a bunch of the other filings and motions in this case. Appointment of counsel, she's indigent. The judge and everybody has kind of done what they need to do. This was filed, by the way, on January 20th. Please advise as to appointed appellate counsel in the aforementioned case. So here's what I'll say. Usually within a month of you getting appointed to a case, you want to talk to your client, right? But what is really important to understand is the appellate process is completely different than the trial process. It is way slower. There are way less things going on, way less updates that are necessary, and way less interaction with your attorney. Doesn't mean they shouldn't talk to you. It doesn't mean you can't ask them questions. It doesn't mean you can't be involved. But I am pretty confident she is not going to be as involved as she wants to be, because one of the first things attorneys have to do, appellate attorneys have to do, is order and wait for the entire trial transcript. Then once they get it, they have to read the entire trial transcript and any motions or hearings or things that are necessary for them to understand what happened at the trial, rulings made by the judge. We read the motion that was filed by Owens, the statement of judicial acts to be reviewed, and motion for court reporter to transcribe designated proceedings. So the appellate lawyer is going to have to read all of that. And you can understand that can take some time, and that's important. And they don't just read it to read it. They don't just read it to check a box. They read it in order, they read it with an eye that is issue spotting. What happened in this trial that might be an appellate issue? Maybe they'll even watch it, because sometimes you can get something from watching it, reading it. Was the transcript right or wrong? You have the benefit of that in this case. That takes a ton of time. And that's a ton of time where you don't really need to be talking to your client every day or every week, because that can take you weeks or sometimes months, depending on how much there is to go through, just to prepare your brief. And I've only worked on a very small few of appellate cases that were my dad's cases, that he appealed his own cases with his client where he tried the case. And we start out with, 1,000 pages, 25 issues. We narrow it down to our best 2 or 3 issues, take out as much as we can. There are word requirements, all sorts of requirements that you need to do. We make sure that we pare it down and only focus on what our best arguments are. Just that analysis takes a ton of time. Now, we usually do talk to our clients And I went through the whole criminal appellate process in Florida with Michael Ufferman, who I think is the best criminal appellate attorney in Florida. If you want to check out that video, it's on our YouTube page. I think it's in the Adelson playlist because he is Charlie Adelson's appellate lawyer. He's somebody else's appellate lawyer too, Wade Wilson, somebody said. But it is a process. It is methodical. You keep your client up to date. You talk to them about what issues you think are the best. You take their input. But honestly, as we talk about legal strategy in a trial portion of a case being mostly the trial lawyer's decision, in appeals, it's times 10, right? Because they know what the legal issues are. They know which ones are going to be good arguments and not. She's, I'm sure, going to have a lot of questions and a lot of theories and a lot of things she wants to argue, but they are going to be limited to the record. You can't just go rogue or go in any direction because Sarah Boone wants to. Now, this is problematic to me that she has not heard from her appellate counsel in a month. And, we'll see if she's heard from him, if we hear from her anytime soon. But she got a response from the clerk. And I found that to be rather interesting, that the clerk decided to respond to Sarah Boone. So let's take a look at what the clerk had to say. The clerk says, in response to your correspondence dated January 21st, 2025, the following applied. Other, Attorney Joshua Adams has been appointed to represent you for an appeal. However, at this time, no notice of appeal is on file. Okay. So Sarah Boone already knows that Josh Adams has been appointed. We looked at Josh Adams' appointment, and what's interesting, and we don't want to make a big deal about this, but to me, when you look at Josh Adams being appointed here on the 18th of December, this is not even actually the first named appellate attorney with Sarah Boone. Now, this happens all the time, not a big deal, but something I found kind of interesting was that the court originally appointed a guy by the name of Alan Holland, which we will take a look at here if I can find the right document. Nope, that's not it. Why is this so difficult? Problem is it won't give me. All right, you guys can just take my word for it. What is the date of this? On December 2nd, Kranick appointed Alan Holland. Okay, it says, after being satisfied of the good faith and truth about the foregoing affidavit, the above named defendant is hereby adjudged insolvent for purposes of appeal. And Alan Holland, court-appointed counsel, is hereby appointed as counsel to represent the defendant in the appeal in the above style case. So Alan Holland was first. Joshua Adams was second. So theoretically, Sarah Boone's already had two lawyers. We're not going to hold that against her. It's not one of these where she's blown a relationship with one. It was probably an issue with either conflict or next person on the list or whatever it may be. But the new lawyer she had, which December 2nd, 2 weeks later is the 18th, more than 2 weeks really, right? So there's some delay there, is when she had the second lawyer appointed. Now, for the most concerning part of this document, no notice of appeal is on file. I looked at the docket kind of quick, right? I didn't do some thorough analysis as if this is my case, but I'll show you guys the docket. This is what the docket looks like. And you go through and you can kind of see what's been filed. And since the trial, you've got the sentence, you've got the final judgment. That's when the notice of appeal time starts ticking. Maybe you could argue they had to amend the sentence for time served. Here it is, amended sentence. So that's on 12/3. Okay. So since then, what we see in this docket, which I didn't pull the appellate docket, maybe it's in there. I actually looked at it, couldn't figure it out real quick before this. I didn't have a ton of time to look into it, but there's a reason we're getting here, right? We've got court minutes, correspondence filed from the judge or filed from defendant to judge. That's the 28-page letter we read together. That was the unedited sentencing letter that Sarah Boone read. Order appointing appellate counsel, which we've already read. Statement of judicial acts to be reviewed. Now, we read that together, and I want to take another just quick look at that, if I can figure this out relatively easily. So when we look at the statement of judicial acts to be reviewed, these are the sections of the case that James Owen said, we think there's some kind of judicial error here, and we want the court reporter to transcribe these issues. Okay? These sections, these motions, these parts of the trial, whatever it may be. He calls Sarah Boone the defendant/appellant. Everybody knows there is going to be an appeal on this case. There were major issues. There were some different things that happened in this case. Her waiving her right to counsel constructively, not actually doing it with her mouth, but instead with her actions. And from my perspective, I think that's a legitimate appellate issue that anybody would appeal. So we all know an appeal is happening. And everything ended in the beginning of December in this case. And the deadline you have to file your notice of appeal is 30 days. Not your brief. You don't have to be done reading everything. You don't have to be done picking out your issues. You don't have to be done prepping for oral argument if you even get one. But you have to file your notice within 30 days. Which is why on January 29th, which is yesterday, when the clerk responded to Sarah Boone and said there's no notice of appeal on file, that's incredibly concerning to me. And then we hear from Sarah Boone that her appellate lawyer has not even spoken to her. Northwest said, if there's no issue to appeal, I promise you there are issues to appeal. I think if I'm wrong about something, it is this notice of appeal has been filed somewhere that we just can't see it. And I'm hoping the clerk is also wrong that there's no notice to appeal on file. But the reason I'm bringing it up is because the clerk said, in no uncertain terms, at this time, meaning January 29th, no notice of appeal is on file. Now, it's weird because they've done a lot of things. They've made sure the court found her insolvent or indigent, so they were going to pay for the cost to do the transcript. They're going to pay the filing fees. They're going to pay everything by the state. She's got appellate counsel not once, but twice. So everybody knows this is coming. So it's very concerning that no notice of appeal is on file. And so whose fault is that is always everyone's question. And it's actually interesting because a lot of people assume that's an appellate attorney's job. And I would say the appellate attorney needs to make sure that a notice of appeal has been filed. And Nicole asks a great question. Could James Owens have filed that or only the appellate lawyer? Very good question, Nicole. And I love this chat so much because they're just always teeing me up for exactly what I plan to talk about next. And this is, we're on D here. This is Florida Rule of Appellate Procedure 9.140 that discusses when you file the appeal, how you file the appeal, the 30-day deadline. But we're going to look at D. Withdrawal of defense counsel after judgment and sentence or after appeal by state. The attorney of record for a defendant will, and this will be James Owens, right? He is the trial attorney. He will not be relieved of any professional duties or be permitted to withdraw as defense counsel of record, except with approval of the lower tribunal, which will be Judge Kranick, on good cause shown, on written motion, until either the time has expired for filing an authorized notice of appeal and no such notice has been filed by the defendant or the state, or after the following have been completed. A notice of appeal or cross appeal has been filed on behalf of the defendant or the state. A statement of judicial acts to be reviewed has been filed if a transcript will require the expenditure of public funds. The defendant's directions to the clerk of the lower tribunal have been filed if necessary. Designations to the approved court reporter or approved transcriptionist have been filed and served by counsel for appellant for transcripts of those portions of the proceedings necessary to support the issues on appeal, or if transcripts will require the expenditure of public funds for the defendant of those portions of the proceeding necessary to support the statement of judicial acts to be reviewed, which he did in this case. In publicly funded defenses and state appeals, when the lower tribunal has entered an order appointing the office of the public defender for the local circuit the District Office of Criminal Conflict and Civil Regional Counsel or private counsel as provided by Chapter 27 Florida statute, that office or attorney will remain counsel for the appeal until the record is electronically transmitted to the court. In publicly funded state appeals, the defense counsel must additionally file with the court a copy of the lower tribunal's order appointing the local public defender, the Office of Criminal Conflict and Civil Regional Counsel or private counsel. In non-publicly funded defenses and state appeals, retained appellate counsel must file a notice of appearance in the court, or defense counsel of record must file a motion to withdraw in the court with the service on the defendant that states what the defendant's legal representation on appeal, if any, is expected to be. Documents filed in the court must be served on the Attorney General. Orders allowing withdrawal of counsel are conditional, and counsel must remain of record for the limited purpose of representing the defendant in the lower tribunal regarding any sentencing error the lower tribunal is authorized to address during the pendency of the direct appeal under Florida Rule of Criminal Procedure 3.800. So, yes, Owens could, the trial lawyer could file the notice of appeal. And many times it's almost expected that the trial lawyer will do that because you just do it to protect it, right? You could also always withdraw it later, but I mean, I'm just telling you, this case is going to get appealed. So I don't know if there is maybe some new rule since I've done a criminal appeal that you can extend this 30-day deadline because of, and I've also never been a court-appointed counsel. I'm not a public defender. I don't know if that delays things like 30 days from the appointment of, or maybe from the issuance of indigent status so they can pay for the transcripts, and maybe the notice of appeal gets extended because of that. From our perspective, for private lawyers, it usually feels like a very hard 30-day rule. A very hard 30-day rule just for the notice. Just for the notice. John said, so Owens dropped the ball. I'm not saying that. I don't know that to be true. And he did do B, which is a statement of judicial acts to be reviewed, has been filed if a transcript will require the expenditure of public funds, which is exactly what he did. How does an inmate know someone is meeting the deadlines for appeal? Well, Northwest, that's exactly why, if this deadline has been blown, which I'm not saying it has, I'm hoping and thinking in my head, I'm probably missing something here because I don't want to believe that the lawyers could drop the ball in this way. Okay. But the clerk said the notice is not on file. And that's why I'm just having this discussion and thinking, I really hope this is not the case in case you can't tell this in my voice. But if it is, that's either malpractice or some kind of reasonable, justifiable reason, because there's nothing she can do to make this happen if her lawyers won't make it happen. But I would think that's not a great ending to Owens or not a great beginning with her appellate lawyer. Peter, here's your big opportunity to take the appeal, or maybe the Know Your Lawyer guy will handle it. Did you miss me? Well, this is a sad set of circumstances if this is what's happening to Sarah Boone, because usually the defense attorney that tries the case will file a notice of appeal just so everybody's on notice. The court knows everybody's on the same page. We're going forward. I cannot seem to find the notice of appeal in the docket. So we will see. Do attorneys ever determine there are no grounds for an appeal? Yes. We have, back in the day, again, when we used to do a lot more criminal, people would call my dad to do their criminal appeal, and we rejected a ton of them. And the ones that we took, the best ones are ineffective assistance of counsel, where you have a 4-week trial and the attorney objected one time. The defense attorney objected one time or asked one question on cross. So we would take those. We would take the ones with major issues. My dad usually preferred to only appeal the cases that he tried the case on because he knew the whole case. He knew the issues. He knew the rulings he disagreed with the judge. So those are the ones that he did the most and that we were most successful on. I mean, we had cases where we won multiple appeals after multiple losses in trial. So that's the process he liked. Melissa, question, Peter, could they watch the trial, for example, on YouTube instead of reading the whole transcript? So yes, they can watch the trial, Melissa. I should ask Ufferman this, because my guess would be that appellate lawyers would not do that in lieu of reading the transcript. They may watch the trial but I would guess they would also read the transcript. Actually, I'm positive they would read the transcript, because when you're, or maybe, I mean, I guess theoretically they could. I would not, I don't think it's best practice, but theoretically they could watch the trial, see where the issues are, and then go back and read the transcript just where there are issues, because you absolutely have to read the transcript in order to cite the record when you're writing your brief. So when you're appealing the case and you say, what happened on page 91, lines 1 through 17, you have to know where that is in the record. You have to write, or you have to read the record. We usually highlight it, or we have programs that we can notate it, make notes on it, highlight it, so we know where to come back from, so we don't have to reread the 1,000 pages every time. And, these programs we have will give us a whole report on every page. We have a highlight, what notes we have on each page. That's usually how we do it, in order, when we're picking our issues and we're issue spotting. And again, it starts out with every issue we can find, and then we narrow it down to what the best issues are. And again, usually we'll do research on what are the strongest arguments, what's the most likely for appeal, things like that. Netwoman, thank you so much for gifting 5 Lawyer memberships. Yeah, you can't hear the sidebars. The record has them. Absolutely. Anytime there's an objection in a sidebar, you got to go up and read that for the record. So I would say, if it was me, I probably would do both. And I might even read the transcript, listen to the trial, then read the transcript again, because I do think listening and watching the trial can give you some of the vibe of what was happening. Thank you, Bob, for gifting 5 memberships as well. Hi, it's not real said, but will the issues change the fact that she's guilty? No. Well, that's not going to be the question, right? The question is going to be, did she get a fair trial? Did she get effective assistance of counsel? Do you think she'll have an issue? Does anybody in the chat think she'd have an issue with her appellate lawyer saying it was ineffective assistance of counsel? I don't think Owens would. I think Owens would say, yeah, it was ineffective assistance of counsel because I needed more time and the court wouldn't give it to me, even though I asked for it over and over again. Northwest said, no, your lawyer would do a great job. Whoops. No, your lawyer would do an amazing job. It's like, maybe. I don't know that guy. So can Sarah represent herself on appeal? She can. It's majorly frowned upon. And after her experience almost having to do that in the lower court, I think that she's going to try to work with appellate counsel as much as she possibly can. And it would be a very, very bad idea to try to represent yourself on appeal. Craig, thank you so much for gifting 5 memberships. People are like paying it forward here. 555. The 555 deal. Who does that? Domino's, Pizza Hut. All right. So I wanted to get on. I want to talk about that because a bunch of you sent me that. And the letter on its own that she wrote, or the notice of inquiry that she filed on her own, was very interesting to me. The fact that she's still filing stuff pro se, but the clerk found it legitimate enough to respond to. They did not ignore it. So if I'm Josh Adams, I'm getting in contact with Sarah Boone. Just talk to her, introduce yourself, tell her that, hey, it's going to take me the next month to read the transcript. I'll get back to you after I read it with what issues. Just explain to her the process. She may still be annoyed at it, but she does deserve to be represented. She deserves to know what's going on in her case, to be able to ask questions, to at least have reasonable counsel there. That's all really important. But I am a little worried that the clerk said at this time, no notice of appeal is on file. So we're definitely going to have to keep an eye on this. It has not gone. You guys, tons of people sent me questions about this. Literally tons of people sent me questions on this. So make sure you guys hit that like button. Make sure you tell anybody that did follow this case that we did this video so they can get their questions answered as well. I appreciate you guys so much for joining me here on short notice for this quick video. So make sure you hit the like button. Make sure you're subscribed. Make sure you comment on what you think about this whole situation. Christy Allen said, could the notice of appeal be misplaced? Yeah, but the clerk should know, right? The clerk should be able to see it. That's what I'm not as worried that I can't see it or that I didn't do some deep dive onto that. The clerk saying that it hasn't been filed is what is bothering me more. And what I'll say is maybe there's some kind of extension because of the indigent status, the state paying for it that, I don't know about because I haven't handled in, private appeals, obviously, where clients are just paying us. So that's what I'm hoping is going on, that maybe there is some extension to that 30-day deadline. But as far as the actual notice of appeal being on file, clerk doesn't see it. I don't see it. That's concerning. We'll see if it means anything. I hope I'm just completely wrong. And next time we're like, oh, yeah, it was done, or there was this extension and no problem. She's going to get to go forward and her rights are in fact protected, because even Sarah Boone deserves to have her rights protected. So thank you guys so much. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know. Decided to do overtime because I saw a couple questions come in that were really good that I wanted to answer. So if you stuck around, you got lucky. If you didn't, I apologize for everybody that left because they thought it was actually over. Stephanie Lang said, is it 30 business days? Is it 30 days or business days? Holidays and I believe weekends don't count, but I think December 3rd or sometime early December is when the judgment and sentencing was. But appellate counsel wasn't until the 18th, and then the affidavit or something giving her the court funds was like the 23rd. So maybe there are a few days in there. Obviously you have Christmas Eve, New Year's Eve, all of those dates, and a bunch of weekends. So maybe we aren't quite to the 30 days, but then again, that would have to do with some special court appointed rule, not the normal 30 days. Big Bapa T does criminal defense. LOL. He can take her case. Yeah. I've talked to him about this case. No way. not his vibe, not his vibes. And then Netwoman, thank you so much. Is appeals only good for trial, or can it be pretrial issues? For instance, can she say that she wasn't warned ahead of time that her last court-appointed lawyer would be her last and she wouldn't get another one? Thanks for always filling us in on all things, Sarah. So yes, it's limited to the trial, but an issue that they objected, fought, lost, and then brought up again, it can be protected for appeal. That will be something that will absolutely be part of the appeal because it's part of the entire trial process on whether or not she got a fair trial, whether or not the judge made an error. And that's going to be in combination, right? Not just that her right to counsel was taken away, but it also made it harder to prep for trial. She had less time to prep for trial, and her attorney asked for a continuance. So that's going to be multiple issues stemming from things that happened pre-trial that were again brought up and protected for the record. So therefore, yes, that is going to be an issue on appeal. Hopefully that answered your question. Now I'm out of here for real this time. You guys are the best. Till next time, peace.